Well, as I was saying, just now that I hit record, I'm Greg Perrick. I'm a CLS Review Counsel. CLS is Community Legal Services at Western Law. I'm going to be doing a presentation tonight on separation agreement. I see it's 6 p.m. now, so we'll start then. What I'm going to do is I'll share the screen, and there's some slides there. We'll go through the slides. I'll try to add some detail there. And then if you have any questions afterwards, I'll take questions. You can put it in the chat, or you can just unmute yourself and ask that question, okay? So I'm going to get started here. Let's see. As soon as I figure out this technology. Okie. All righty. Hopefully you can see that. Okay, perfect. Make sure we're recording. Okay, so this is, as I said, a presentation on a separation agreement. This presentation is being put on by Community Legal Services at Western Law. Please note that the presentation is only providing general legal information and not legal advice. Like I said, at the end, I can do a Q&A, and I can give some general advice, but I can't give specific advice about any person's matter. Okay. Yeah, this presentation is actually being put on by a lawyer this time. I'm a lawyer. Sometimes our presentations are put on by a law student, and as I said, a Q&A session will be available at the end if anybody has any questions. Just note, if you do have any questions about separation agreements, note that it's not confidential. This is a public forum. This is going to be posted online after. So if you do have any questions, keep it general, because again, there's no confidentiality. Okay. And before I kind of get into the substance of the presentation, we need to do, and we should do, a land acknowledgement. So I acknowledge that Western University is located on the traditional lands of the Anishinaabe, Haudenosaunee, Lenape-Wauk, and the Chinungten nations, on lands connected with the London Township and Sombra Treaties of 1796 and the Dish with One Spoon Covenant Wampum. I respect the long-standing relationships that Indigenous nations have to this land, as they are the original caretakers. We acknowledge historical and ongoing injustices that Indigenous peoples, First Nations, Métis, and Inuit endure in Canada, and we accept responsibility as a public institution to contribute toward revealing and correcting miseducation, as well as renewing respectful relationships with Indigenous communities through our teaching, research, and community service. I hope for the public that hits home, and that's not just a recitation of something off a screen, and that this is taken seriously and given it due. So a separation agreement can also be broadly defined as, or referred to as, a domestic contract. Don't get hung up on the idea that whether you're married or unmarried, it's still a contract that deals with kind of the family issues between a couple upon breakdown of the relationship or separation. So, folks who may have been separated for quite some time, don't be thrown off by the idea that this is separation agreement. That you can call it that, but it's also a domestic contract broadly. what does a domestic contract do? What can it do? What kind of things does it cover? It can include all kinds of legal issues. It can talk about child support, spousal support. It can talk about the parenting plan, who has parenting time and when. It can talk about decision making, which used to be called custody, now called decision making. So you could have a joint decision making scenario. You could have a sole decision making scenario. You could have a scenario where one parent gets the final say, but must consult with another party with the other parent with respect to any major decisions. It can also, if I haven't mentioned it already, it can involve property issues in terms of a division of the party's assets accrued during a marriage. And that's called equalization of net family property. We're not going to get into that tonight because that's a pretty complex issue. And in fact, at Community Legal Services, we don't do that type of service because that is our policy with respect to the type of matters we take. Typically, folks who can afford to do an agreement or go to court over equalization of net family property, they probably don't financially qualify for our services. So it can also deal with even minor issues with parenting, like where do the pickups and drop-offs take place? What time does it take place at? Is a third party going to be necessary to facilitate the pickups and drop-offs? The advantages of a domestic contract can be that, one, it helps to avoid court. The court process is, especially being backlogged through COVID, is a long and strenuous, stressful process, not just for the folks that are in it, but especially for the children. If children are involved, they may not feel directly the stress of the case, but believe you me, the children are feeling it indirectly. And these cases can, if they go to trial, they can take 3 to 4 years. And if you do a domestic contract and both parents are or both parties are making a good faith effort, using their best efforts and trying to resolve matters through a domestic contract, it could possibly take a fraction of the time court can take. That's not true in all circumstances, but it can be a way to avoid that stressful court process. Going along with that is, if you go to court, you're likely going to need a lawyer if you can afford one, or even if you can't afford one, you're probably going to feel the pressure to get one, and that it's an expensive endeavor, unfortunately. But that is the reality of court. Court is very expensive. The court is, judges will often say that if a matter goes to trial, it could be anywhere from $5,000 to $7,500 a day. I don't know too many people in London who could afford that, frankly. So domestic contracts and separation agreements or even a parenting plan contract can really help avoid possibly mortgaging your future for just to address parenting issues. So that really needs to be considered. Well, I will talk about, because I was going to say, the best thing you can do if you can afford it is to try to speak to a lawyer, even on, with an hour of their time, to see, what is the more appropriate path. Do we do a domestic contract or do we go to court? And as I already mentioned, a benefit of a domestic contract is that it can be easier on families with children. And that would take, again, both parents or the parents, depending on the family dynamic. It if they're both making an effort and cooperating, it can really avoid a lot of stress on the family. Who can do an agreement? Who can draft one? Who should draft one? Generally, any separating or separated parties can draft an agreement themselves. We call these, or you may call them, or you may hear them called a kitchen table agreement, with the idea that, separating parties or parties who need a parenting or family plan or domestic contract done have decided that they would sit down together and perhaps hash one out. Ideally, we discourage that, at least without getting independent legal advice from a lawyer, because there are some pitfalls that you can run into. With respect to drafting the agreement. You may, draft the agreement just between yourselves. You may sign it and then, find out maybe years on down the road that it's not worth the paper it's written on, essentially. So if you're going to do it on your own, I would still recommend the following. Get independent legal advice from a lawyer. What this is, it's also, and I'll talk about it on the next slide, but it makes sense to get to it now. Independent legal advice is also referred to as ILA. And typically this is 1 hour of a lawyer's advice. And if you are interested in doing that, and I encourage you to do that, you call them and you specifically ask for independent legal advice. And you ask them that you want independent legal advice on an agreement that's already been drafted, whether it's been drafted by the parties themselves or by an opposing counsel. This really allows the lawyer that you go to, even if it's for 1 hour of advice, it could enable the lawyer to look at whether any of the pitfalls are going to occur. Maybe, and I'll talk about this now. Maybe there aren't witnesses. Maybe it's not dated. Maybe it's not signed by both parties. Maybe it's not meeting the objectives of family laws we know it in Ontario. So even an hour of the lawyer's time, they can really get a sense of whether this is an agreement that's appropriate or not. That doesn't mean that they're going to change it for you. That's not what the independent legal advice would be for. It would be to see, one, whether this agreement is valid. Two, what are the nature and consequences of the agreement if you sign it? Well, what are you getting yourself into? What are your rights and obligations under this agreement? You're probably not going to get fulsome advice, right? Because it's just an hour of the lawyer's time, but it will hopefully give you a snapshot of what your agreement is like in terms of the law. I strongly encourage the public to, if they're dealing with financial issues, so child support, spousal support, equalization of net family property, dividing the value of the assets between the married couple throughout the marriage, you must, in my view, exchange full financial disclosure. And I'll talk about later what that is generally. You should also, like I said, have that contract witnessed and dated. And you should take time with the agreement. You should consider it, and especially what I talked about, the nature and consequences of the agreement. I definitely understand parties' desire and need to perhaps close a certain part of their life and move on. That makes perfect sense to me. And the sooner you do it, the better, in the moment. However, if you don't take time with the agreement, you could make decisions that could, bite you in the butt on down the road. Maybe you make some concessions that you really didn't want to do. Maybe you didn't really, really consider your rights and obligations, what that really meant once you signed on the dotted line. So take time with it. And I'll also speak in a couple of slides later why that taking time is also important. Excuse me. So I talked about independent legal advice. I also talked about, you should get it even if it was drafted by another, or especially if it was drafted by another lawyer, and really equally if it was drafted by your former spouse or someone else. You should get it looked at. Why? Because it's short-term pain for long-term gain. I know lawyers are expensive, believe you me, but you could, especially with financial issues, if you don't meet certain criteria to cover your butt from a legal standpoint, you could say, for example, you had made some kind of agreement with respect to a division of property or some kind of payment in lieu of something, and you didn't understand the law and you didn't do financial disclosure. There is a real chance that agreement could be overturned in the future. And perhaps there could be all kinds of consequences because of that. So you want to make sure that you are getting the best advice as possible on the agreement, because the ramifications could arise later. Okay. Like I said, it's strongly recommended that you get ILA. If you cannot pay for a lawyer, you can try contacting legal aid. The number is in the slide there. You can also try the lawyer referral service. The lawyer referral service number, however, only gives free 30 minutes of advice, and I do not think that is probably, I don't think you'll be able to have your separation agreement or your domestic contract reviewed in that regard because it's over the phone. So I really tried to get, ILA, independent legal advice, have a meeting with a lawyer, even if it's on Zoom and you're sharing the screen like I am now. A lawyer will need to have eyes on the contract to give advice. Over the phone, you can't see what the terms are. You can't see the whole agreement. So again, I repeat until I'm blue in the face. Try to get independent legal advice on the agreement, if nothing else. So I spoke about financial disclosure and the importance of that, because a domestic contract is very vulnerable to being overturned if there's not full financial disclosure, and some financial terms were agreed on in the contract. So what does it full financial disclosure look like? For support issues, it should be that both parties exchange their last 3 years tax returns and their last 3 years notices of assessments. The reasoning behind the last 3 years is so that, if you have a payor of support whose income fluctuates, you perhaps would have to average that out, because it would give a sense of the pattern of income. Perhaps 1 year it's 20, the next year it's 50, and the next year it's 30. So what number are you going by there? What number is going to meet the objectives of the child support guidelines? So exchanging those last 3 years instead of just the most recent year will cover off that worry that there's a fluctuation in income. I often find that in family court, some folks need to identify the different, because maybe they've been ordered to provide tax returns and so forth. There seems to be an assumption that they're one and the same and that they're interchangeable. They're not, right? The tax return is what you submit to the government when you do your taxes, and it's a proposal of sorts of, this is what my income and expenses were, and this is how much I owe. The Canada Revenue Agency has a opportunity to assess that return. And then if they deemed it, acceptable, they will send a notice of assessment. So in many cases, it's not enough just to see a tax return, especially if you think about folks that are self-employed. We don't know what they have been claiming on their expenses. We don't know how they have structured their income. And so seeing not just the tax return, but seeing what the notice of assessment is, will give you a full picture of what's being claimed and what someone's income is. Why is it important to make full financial disclosure? Well, we already talked about there's a risk of the agreement being overturned in court if it is ever challenged. It ensures that both parties know the other's full financial circumstances. So there's not some moment on down the road, far past separation, where one spouse finds out the other was actually making $100,000 a year instead of 50, or was getting bonuses that they didn't know about, or was working overtime that they didn't know about, or had assets that they didn't know about that perhaps they were concealing for whatever reason. Full financial disclosure eases that particular worry, and also makes the agreement harder to overturn. That's not to say that it wouldn't be overturned, but it makes it harder to. And full financial disclosure just makes sure that the parties are considering the objectives of the child support and spousal support guidelines, making sure, particularly from a child support standpoint, and in later slides, I think I referred to the fact that child support is the right of the child. Parents don't have the capacity really to contract out of child support. If you both agree in some manner to not pay child support, if the parents don't agree, whatever, again, the family dynamic, that child support isn't payable, the contract should explain why. Some circumstances are that the parties share parenting on an equal basis and they have relatively the same income. If that's the case, then explain that in the agreement. And I will, in a later slide, explain why. What else should be disclosed? In my view, if there are support issues only and not property issues, you should still be exchanging a Form 13 financial statement. This is a form that can be found on ontariocourtforms.com, and it is a court form, but it still has utility outside of court. We use these to show to the other party, it's a sworn document, to show the other party what our client's income is, what their expenses are, what benefits they may have from their work, who else lives with them, and do they have income? What debts and liabilities do folks have? This form allows, within its four corners, to really give the other side a view of the full picture of, in addition with the financial disclosure of tax returns and notice of assessment, the Form 13 really gives you that full picture of what's going on. And then you have the added kind of accountability that this is a sworn document. This person swore to it and said, these things are true. My expenses are this, my income is this, and so forth. The other document, so if you have married a couple who have separated and they have assets that need to be divided, you will need to do a Form 13.1 financial statement. And that captures not only support issues, but property issues. I strongly encourage that if you have issues of equalization of net family property, that you speak to a lawyer. There is definitely no way tonight, that I could explain in a nutshell what equalization of net family property is. So please get independent legal advice at the very least with respect to property matters, because there can be very complex issues, especially with tax implications. So make sure you're mindful of that. So I spoke earlier about giving yourself time. Just hold on a second. I just want to see. I don't know if there are other participants in the waiting room. Does not look like it. So I'm just going to keep going ahead. A little worried there were all kinds of folks in the waiting room trying to get in. So in the previous slide, I talked about taking your time with the separation agreement. And you should do that, one, to make sure that you understand the agreement. But two, an agreement can be overturned if there is some sense, and you have to have evidence, but that the other party was either pressured or coerced, or they were under duress, or there was some kind of undue influence that compelled them to sign. They weren't signing voluntarily or under their own volition. If you don't take your time with the agreement, and one example is quite common, is when folks get separated and say they own a home and they both want to buy, or maybe one party wants to keep the home and the other party wants to buy a new home. Folks will often rush into a separation agreement or a domestic contract to get it done, because a lending institution won't give them money if they don't have some kind of contract that talks about what their financial obligations look like. So they'll rush into it. And this is a very bad idea, even though I 100% get, that desire to move ahead. But if there's that kind of feeling of being rushed and this having to be done, it's not uncommon for former spouses to email or text each other and say, like, have you signed the agreement yet? Have you talked to your real estate lawyer yet? Have you talked to the realtor? All of that stuff, while both parties may feel like this is something that needs to be done, there could still be some element of coercion there or pressure. And as I say in that second point, this can happen without the parties realizing it. That's not to say that, the agreement would be overturned, but I would err on the side of caution and take your time, because it's just going to benefit you in the long run. Again, short-term pain for long-term gain. So I spoke a little bit about child support and it being the right of the child. The court is clear, case law is clear. You can't, parties can't contract out of child support for the children or the child. You can certainly, for a time, probably, if nobody ever makes an issue of it, and you're not applying for a divorce and you never set foot in court, perhaps that is something that you could get away with, for lack of a better phrase. However, it is not uncommon at all, and I think it's becoming more frequent. So folks who have been married and then are seeking a divorce, maybe they've drafted a domestic contract, and things are amicable, and they've decided, we're not going to pay child support. I'm good, you're good, whatever. If you don't explain why there is no child support provisions and you apply for a divorce with that separation agreement or domestic contract forming the basis of your divorce, the court is very likely to reject it. The court wants to see parents turning their minds to child support arrangements. If there is a disparity in income and there is a primary care situation, say, and there's a secondary parent who has less than 40% of the time, there should be child support being paid. The court is very worried that, children aren't being provided with support just in some zest to get the divorce done, to move on. Because you don't know what kind of circumstances are happening. Maybe there is a parent who does want child support for the child, but again, it maybe doesn't want to bother with it because, the other spouse will be upset. I just want to get this divorce done. Why are you bothering with this? The court wants to make sure that everybody is slowing down and turning their minds to getting this child support, getting the child support provisions solidified, and that they're in the within the objectives of the child support guidelines. And so, like at the last point there, again, the divorce could not be issued. I've even seen folks who have gave up on trying to get the divorce because they did not want to really, or perhaps did not know how to explain to the court why child support is not being provided. So really make sure you are cognizant of, this element of a separation agreement or a domestic contract, and then how that plays into possibly if anybody is seeking a divorce based on that contract. So there are some kind of standard boilerplate clauses that you'll see in separation agreements or domestic contracts, and I just kind of wanted to explain what those are. Obviously, they will have longer phrases. These are just kind of a shorthand of what these clauses mean, but they are important and they serve a very important purpose for the separation agreement. You really want to make sure that they're included in a domestic contract. So the first one is severability. So what this means is, if there is, for whatever reason, some term in an agreement that is becomes void for, again, whatever reason, severability means that that clause will just get cut off from the agreement. It will get severed from the agreement, and it won't spoil the rest of the agreement. So, somebody couldn't take advantage of some kind of technicality and say, oh, if that clause is out, this whole thing's done, I'm out, I'm washing my hands. That's not the case at all. The severability clause will be in there to make clear that, okay, we'll just get rid of that clause if it's void for whatever reason. They also talk about the timing of signing, and what I mean there is, and usually the language is something like, this contract or this agreement is effective when the latter party signs it. So be mindful of that. If you have signed an agreement and, you didn't sleep on it and the other party signed it, most people will argue, and perhaps very successfully, that this is a contract. There's now been this offer and acceptance. Both people have signed it. And so right built into the agreement. Sorry, just letting somebody in. Built right into the agreement is a clause that says this is going to be effective when the latter party signs it. So again, that kind of flows into the next point, and I mentioned it earlier. Make sure that you understand the nature and consequences of the agreement. because the agreement's going to say that. There's going to be a declaration that you understand the nature and consequences of the agreement, that you understand the rights and obligations of the agreement. So when you're signing that agreement, you are stating that, you're declaring it. So it would be very hard, as you can imagine, if you went into court and you said, I didn't understand what I was signing to. The court's going to say, well, that particular clause is in there, and you signed it. Did you not look through the whole agreement? To combat that, again, independent legal advice, because then at least maybe in an hour of a lawyer's time, they can tell you about the nature and consequences, the rights and obligations, and anything else that may really jump out at them. An agreement will also include a declaration of, did the parties get independent legal advice? Who gave them independent legal advice? What lawyers? But it can also include a waiver of independent legal advice. And I only say that because that's what it can include. But again, I urge you not to do that, right? If you can get independent legal advice, get it. Short-term pain for long-term gain. Also, there will be a clause in there, a boilerplate clause about financial disclosure. Was it done? Were financial statements exchanged? Were tax returns exchanged? If you declare that full financial disclosure was made, you should be exchanging full financial disclosure. You should not just be saying you did it. Make sure you make note of what you exchanged. Copies should be made so that you have a track record of, yes, I gave you this. If you can email it, that's perfect, right? Because that's a record of it right there. There could also be a clause that there's a waiver of financial disclosure. Some folks could agree that oh, we don't need to do financial disclosure. And then you could declare that you waive your right to that because you do have a right to financial disclosure. Again, I would really discourage folks from waiving this. And then there's also, and this isn't on the page, but it has to do with financial disclosure. There will be a clause in the agreement too that speaks to the notion that a lawyer or somebody, or you have made yourself aware that it's a possibility that a lack of financial disclosure could result in your agreement being overturned. That's going to be right in there so that, if it goes to court, a judge is going to say to you, you understood the risk you took in not fully disclosing your financial circumstances. Another boilerplate clause that you'll see is the idea that there will be a provision that says there's no collateral agreements. No other prior agreements out there are going to have any force and effect. This particular agreement that you guys are signing is going to override all other agreements. I tell clients, this includes unspoken agreements, head nods, handshakes. Those are out. And I tell my clients, whatever you're going to agree on, it's within the four corners of this agreement. Do not, regardless of how amicable parties may be, make sure you get it on the page. You don't know what's going to happen in the future. I want to be optimistic, but sometimes things fall apart. And then when things fall apart, people start to allege things that may not be true. I didn't sign this. No, we didn't talk about this. So make sure that you are recording within the four corners of the contract everything that's agreed on. There's no other agreements. Another thing that is going to be in the agreement, and you should always remember, no matter how amicable you guys are, if you're ever going to change the agreement, change it in writing, sign it, have it witnessed and dated. Again, you don't know what's going to happen in the future. If you had made changes to the agreement with respect to child support or the parenting arrangements or things like that, if it falls apart and there's no record of that, there may be a chance that the other party could say, no, I didn't agree to that. No, that never happened. So you just want to make sure that you protect yourself. So that is kind of an overview of separation agreements. Obviously, there are hundreds of issues that, smaller issues that could arise. And that's why, again, I will go back to, if you can, afford even independent legal advice, an hour of a lawyer's advice, and you have the agreement ready, you can show them that, and you can hopefully get a peace of mind that you understand the agreement, and what is going to happen if and when you sign it, and what that means for you moving forward. Okay, so I'm going to stop sharing and open it up to any questions. You don't have to. You can put it in the chat if you want. I will just be quiet for a couple of minutes to see if anybody wants to ask any questions. Okay. I think, Maria, you're trying to unmute?
Yes. Thank you for your presentation.
Yeah,
I have a question about, for example, if my husband is not agree with nothing, what can I do? Go to the court?
Yeah. Yeah, unfortunately. Yeah, so the nature of domestic contract is it's only enforceable if both parties agree to it, right? So if you've been trying to get an agreement for a while or you're just being ignored, court may be your option. You could also suggest mediation. I don't know. I see Christina has asked if separation agreement is the same as mediation. No, it's not. So and I'll try to answer both of your questions with this explanation. So a separation agreement is something that you draft, and it's kind of the result of either negotiation or could be mediation. Mediation is where you have a mediator, who they're a licensed mediator, a certified mediator. They are an independent party that can try to facilitate some agreements on some or all of the issues between the two of you, or whatever parties are involved. The mediator, again, doesn't have any interest in the case, is not connected to anybody. They are just a third party trying to help folks out and see if they have some common ground for an agreement. It should be noted that a mediation, what comes out of mediation usually is called a memorandum of understanding. That is not an agreement that is enforceable. That's not a domestic contract. That's not a separation agreement or a parenting plan or whatever you want to call it. It's not enforceable. But you can turn it into a contract by either taking it to a lawyer who will draft the contract, give you advice on it, and then the other party will have a look at it, perhaps, hopefully, take it to a lawyer of their own. And then once that's signed, after getting, hopefully, independent legal advice on both sides, that then becomes a contract. But mediation is kind of the negotiation part with a third party to try to get to those agreements. So Maria, if, and I don't know the situation and I can't give specific advice and I don't want you to give me specific details, but if the other party is, doesn't want to draft an agreement by themselves, but need some kind of facilitator, maybe a mediation is possible. But mediation is not for everybody. Mediation can be inappropriate in some circumstances, particularly if there is intimate partner violence or domestic violence. Then that creates some kind of power imbalance in negotiations, right? I mean, how do you negotiate with somebody that you could be afraid of, very afraid, right? So it's really hard to assert your rights and what you're entitled to when you fear somebody. So mediation can assess. So anytime you do mediation, there will be an intake process, and the mediator is trained to assess whether mediation is appropriate for the parties. I just recently had one that wasn't accepted, but that happens. So I don't know, Maria, if that's an option, but obviously that's something that I can't answer. And then, after that, it's likely court. Okay.
Thank you.
Oh, no problem. I'll just wait a couple more minutes in case you guys have any more questions, which is completely fine. I'm here.
Okay, I have another question. In
Okay.
my case, I left from my home 2 weeks ago. No, 2 months ago. Yes, I left. And we are sharing our kids 1 week and 1 week.
Yep.
What is the problem in that case? Because I told with my husband about that agreement, but he said no because I left. And I don't receive nothing from him. I don't have job.
So you're spending 1 week in the house and he's spending 1 week in the house?
No, our children.
Okay.
I live in a different house. Yeah.
Okay.
We share the kids.
And your question is that okay?
Yeah, because I don't have a job. I am immigrant.
Okay.
I left because I was in a financial abuse, and I decided to left. Yeah,
Okay.
and he say, okay, we can share the children 1 week and 1 week because he doesn't give me nothing.
Okay.
Do you understand?
No, I thank you for telling me that. So I can't give you specific advice, but what I think you should do is call legal aid. Have you called legal
Oh,
aid?
yes, I have.
And do you qualify for a lawyer?
Yeah, I already have a legal aid certificate, but I'm waiting for the lawyer.
Okay. If you can't find a lawyer that will take your certificate, you can call community legal services. I mean, I don't know if we can take your case. I don't know anything. But you can call community legal services as well. Okay. But if you have a certificate and you qualify, you should try your best to keep looking. I'm going to send you my email. Okay. You email me if you are stuck.
Okay. In where you are working, do you accept legal aid? Because not all the lawyers accept that legal aid.
So the Community Legal Services provides assistance kind of for folks who don't quite qualify for legal aid.
Oh,
Okay. If you have a certificate, we encourage you to take that to a lawyer who does legal aid work through a certificate. If you email me about who you've contacted, if you can remember, I can also give you a couple of names to see if they can help you, okay?
Okay, thank you.
Yeah, no problem. Again, I will just wait a couple of minutes here.
I have a question.
Okay.
Sorry, I was late. I almost missed the the meeting. So I'm currently doing mediation, and that's what I was asking if this is the same as a separation agreement. So once that memorandum is done, what proceeds? Like, do I still need to go to court to get the divorce settled, or what happens?
Okay. Are you in court right now?
No, we're just doing mediation.
Okay. So you can, so once you get the memorandum of understanding, like I said in the earlier slides or just in Q&A, it will then need to be put into a domestic contract, right? And then you should get independent legal advice, or better yet, have a lawyer draft that agreement, and it will likely take, it will be less expensive and be quicker in that case because your agreement's already agreed upon. They're just going to formalize it so it's enforceable. Okay. And then the so that's done. So that would be done. And all of the things I've said tonight about the contract,
Right.
you should strongly consider all of those things. So
Yeah.
after you've it's signed up, it's hopefully you've met all of the things that I've talked about tonight, and you've covered that off. If that's all signed, you can apply for a divorce. You can do it on your own, or you can call a lawyer. But I would encourage you to also check out Steps to Justice. You can Google that. Excuse me. And there is general information there on how to do what we call a simple divorce. It's kind of a silly name because divorce doesn't seem simple at all. But that's what it's called. And it kind of gives you general steps on how to do it, how much it costs. But the rule is that for you to apply for a divorce, you have to be separated for a year or longer. So you want to make sure that that is in place as well if it's not.
Okay.
Okay.
Right.
Okay.
Okay. Now, I heard you mentioning about legal aid. How can I apply for it? Is there a website where I can go to for it?
So the number in the slide, I'll put it in the chat here. You can call that number and you can go through the intake process with them. I'm just looking it up on my phone here because I don't want to close the screen. I may never get back to it.
Okay.
I should know it off the top of my head by now, but okay. I'm going to put it in the chat, and then you can both tell me when you have it. Because when I close this, it will disappear, right?
Yeah.
Okay. Double checking. Okay, perfect. So again, just let me know when you've written it down or copied and pasted it.
Okay. Yeah, I took a screenshot.
Okay.
Yeah, thank you.
Do you have it, Maria? Okay. Any other questions?
That's it for me. Thank you again.
No problem. All right, then I saw Maria shake her head too. So what I will do is I will close it up. We will post this online later. I don't know how to do that. Somebody else does it. But we'll make sure that it gets on the appropriate pages. I think it's on our Facebook page and on our YouTube page. So you'll be able to watch it back. The slides will be available on the recording. Okay. Thank you so much for attending. We really appreciate it. We're going to be doing more of these in the future as well, just on different topics, but you'll get notice of that just like you did last time. So thanks again. Have a good night.
Yeah.
Thank you. Have a good night.
Yeah,
Good
take care.